I'd like to introduce today's speaker. John Petrella is a shareholder of the Davis Brown Law Firm and serves on the firm's board of directors. As a member of the business division, John practiced primarily in the areas of telecommunications and utilities, agribusiness and corporations, business organizations and transactions, and mergers and acquisitions. John assists clients in merging risk and capitalization on opportunities associated with innovative business strategies involving regulatory frames. I'll turn it over to John. Thank you.
Thank you, Christy, and welcome everyone. I want to thank the ISBA and the Corporate Counsel section for inviting me to speak today. Always a pleasure to get out of the office and come over to the headquarters building and take advantage of this excellent technology, and again appreciate the work that Christy did in helping us prepare for the seminar. As Christy mentioned, my name is John Patel and I am a shareholder at the Davis Brown Law Firm. I do work with business organizations, especially businesses in regulated industries, including relevant today telecommunications, but also general business and regulatory work. We're here today to talk about consumer data privacy, which will impact your practice and your business, I think, across many different fields and industries. But we will talk specifically about some telecommunications specific data privacy concerns simply as an example for what we want to discuss. So consumer privacy, why does it matter? I think that's a fair question for anyone, including a client or attorney, to ask. We've got a couple of things that I would call everyone's attention to, and it matters because it matters to regulators and it matters to lawmakers. And so in February of 2012, there was a White House paper that was published. That White House paper did introduce a concept called the Consumer Privacy Bill of Rights, which does lay out, I guess, in a non-binding way, some aspirations or some principles that this administration feels are important. Maybe more important in particular to those of us practicing with clients in regulated industries is an FTC report that came out in March of 2012 that did match or match up closely with what was introduced by the White House in its white paper. Of course, the FTC report and the White House white paper both come in an environment where high-profile data breaches are in the media, if not daily, certainly weekly, and I've listed just a few. The Sony Pictures breach, of course, maybe not as consumer-oriented as some other data breaches, but certainly was in the news and was mentioned again by the President in the State of the Union address as one of the reasons or examples of why data security is so important. That was a recent Sony Pictures data breach. Home Depot, JP Morgan Chase, big news in the Midwest, of course, with the data breach at Target, Citibank, and the Sony PlayStation Network. And I put that up there just to show Sony, again, being involved, and obviously Sony Pictures and Sony PlayStation Network are different. But even those entities that know or expect, including the banks and those who've experienced data breaches previously, are having a difficult time controlling the security of their data. And so, again, an important, I think, factor for all businesses to consider. So it matters, of course, because of risk. And so as attorneys, we like to think that we can help our clients identify and manage risk, whether that's as in-house counsel or outside counsel. You want to have a discussion with your client about their data management practices and the risks that come with data. So as data becomes a more important and critical asset for companies, I think we need to think about the risks, and of course those can be quantified as many risks as legal, financial, and reputational risk. I think there's a fourth one that I didn't think to put on the slide, but investment risk. As data becomes a more important investment for your business or for your client, misuse or misappropriation of that data could cost you in terms of the investment that you've made in that data. If it suddenly becomes impossible for you to use or is used by a competitor, that can have a negative impact on the return on investment for the data that you have in your possession. Security breach disclosure laws, and so when we talk about financial risk, one of the other risks is reputational risk, and I think both financial and reputational risk are incorporated into the security breach disclosure laws. Iowa does have a law. I think there is a law now in all 50 states. Can be significant differences between the laws in those states, and so depending on what sort of data has been disclosed and what's involved in the breach, you may have a reporting requirement in one or more jurisdictions, and that may require you to give notice to affected parties. It may require you to give notice to federal, state, or local agencies, and it may require you to offer or to provide credit monitoring or credit reporting services to consumers whose data may have been misappropriated. And so you are going to want to understand, I think, in connection with any analysis of risk, what sort of data is involved and what sort of reporting requirement may be involved if there is a breach of your safeguarding requirement. Numerous state and federal laws. Again, I think there is now a security breach disclosure law in all 50 states. There are numerous federal laws, and later on I'll try to describe those as sectoral. There is not an overarching federal law right now. That is being considered. I believe there may be drafts circulating in Congress currently for a federal law that would try to provide at least some umbrella guidance to entities who may be impacted regardless of jurisdiction. I can see some benefits and some drawbacks to having that federal law, but that is currently under consideration. Currently, though, your federal laws are going to be sectoral, whether it's the financial and banking sector, whether it's the telecommunications sector, whether it's healthcare, to name a few that are more common. International laws, in particular with data privacy, Europe is a frequently cited jurisdiction for fairly aggressive from a consumer protection standpoint and disclosure standpoint. Certainly some of what was in the President's white paper and in the FTC report that I mentioned earlier comes right out of the experience in Europe. And so those entities with international operations are frequently already maybe on the leading edge of data privacy or consumer data privacy, especially here in the U.S., based on the compliance efforts that they've got to have to comply with EU and other European standards. In the news, Microsoft and Google, to the extent they operate without much government intervention here in the U.S., it seems are frequently involved in spats with regulators in Europe, especially on this data privacy issue. So today we're going to talk again about data privacy, just a quick overview of what I hope we can get through in our hour together. We'll talk a little bit about contracting with third-party vendors, the contract diligence piece of that process, the contract terms as a separate piece of that process, contract performance. I want to point out a few notes that I think will be helpful to you in practice. And then finally, if we have time, I'd like to provide a specific example, and that's CPNI, Customer Proprietary Network Information. We don't want this to be a seminar or webinar about CPNI, but with my background in telecommunications, I think I can give an example that then fits pretty well in whatever industry or whatever area you are working in. At least in my experience, consumer data privacy is starting to firm up around a few key points, and much of this sectoral data privacy requirements, I think, translate from one sector to another. And so we'll use that specific example again, maybe just to give some real-world experience to what we discussed earlier. Contract diligence. I think the first part of your contract diligence when you're contracting with any party, whether data is or is not involved, is to do that initial assessment. As I touched on earlier, I really encourage attorneys and I suppose the business side as well to view data as an asset, and especially consumer data. One of the reasons that it is important for us to protect it and to act responsibly with it is because it has value to the organization or to the enterprise, whether for your own use or for whether for using with a third party in some responsible and allowable manner. Don't forget that this is an asset. Now, it's an asset that carries some risk with it, and so like any risky asset, when we've got a contract that deals with that asset, we want to be certain that we recognize that, number one, the contract does have implications for our data and for the portions of our data that we may identify as riskier than other portions. We also want to be able then to, within the contract, find reasonable and responsible ways to respond to the risks that our data carry with it. So you've got to, I think, as an initial matter, assess the privacy and security law that applies to your data. And so I've got a list here of just a few of the sector-based federal laws: HIPAA and high-tech, which of course is healthcare; Gramm-Leach-Bliley, which is the banking and financial sector; COPPA, which is children's online privacy; FERPA, which I believe is education; FACTA, which again is financial; FISMA, I cannot remember what FISMA is. I should have refreshed my memory on that. But those privacy and security laws are very important. You've got to be familiar with the privacy and security law applicable to your sector, if any. And you also, I then think, need to understand, again, how that law applies to you. So in an analysis of a sector-based federal law or a state consumer reporting law, consumer breach reporting law, I think it's important to ask a couple of questions. And I would just suggest that as part of that analysis, you want to ask first, number one, who is covered by this law? Does this apply to my client or to my organization? Second, look very carefully at what types of information are covered by that law, or what uses of information are covered by that law. So, does it apply to us? And if it does apply to us, what pieces or parts of our information or what uses of our information does it apply to? Don't forget to look at what is exactly required or prohibited. So you want to understand, if you're covered by one of those laws, what does that law require or what does it prohibit? And then again, with the contract assessment, how does that impact the contract that you may be reviewing, that you may be giving comments on, that you may be negotiating? The other questions, I think, are maybe less important at the time that you're contracting, although the final one is obviously important. But who enforces the law? What happens if we don't comply with the law? And why does that law exist? So I think if there's a regulation of consumer data privacy, you can assure yourself that one of the reasons that law exists is that lawmakers have determined that information, if falling into the wrong hands, could have adverse consequences to your customers or to your consumers. That can obviously blow back as reputational and financial risk, as we discussed earlier. And so if you are covered by one of these laws, I think it's extremely important that you understand what these laws provide. Even if you're not covered by one of these laws, I think it's important for you to understand that these laws exist and why they exist. And you can then draw, I think, some reasonable conclusions about how much or how little you should be concerned about protecting data that you may have that isn't necessarily covered by one of these laws. Privacy policy and customer agreements, you cannot lose sight of the fact that your organization or your client may have one or more privacy policies or one or more customer agreements with consumers whose data may be shared with a third party. In that case, it is absolutely critical that somebody can play the role of assuring that anything we do on a contract basis is not inconsistent with what we've got out there for our privacy policy or our agreement with consumers. There's been more and more activity, both at the state level and at the FTC, in bringing unfair practices claims against companies who say one thing in their privacy policy and then do a second thing or a different thing in practice. And so it is sometimes the case that somebody will adopt or implement a privacy policy on the advice of outside counsel or in-house counsel who work on that, get everything all set up and ready to go, have that posted on a website or have that provided at the point of sale to a consumer, and then promptly forget about what that privacy policy says. There may be other attorneys or other outside counsel who work on contract or other issues, and nobody really takes the time then to synthesize what is happening with consumer data as opposed to what is committed in our policy. And so you just want to be aware that a privacy policy can, in some circumstances, create a legal obligation to use the data in the way that you've said that you would use it, or more particularly, not to use data in a way you specifically said you would not use it in your privacy policy if a consumer has relied on that. A customer agreement is maybe more obvious. If you've agreed to use or not use information in a certain way, you don't want to enter into a contract with a third party, which is going to breach your agreement with your customer. Regulatory certifications, those of you who might serve as the compliance officer for your organization, or those of you who might assist those folks with some of the certifications that need to be made to federal agencies will be aware of this. But obviously you don't want to enter into contracts, or if you can change terms of contracts, you're going to want to insert terms that are consistent with certifications that you may make to a regulatory agency that has jurisdiction over your operation, and in particular your operations involving consumer data. And we'll talk about a specific example with CPNI. But if there is an annual or another regular certification that your enterprise needs to make to a regulator, you want to be certain that your contracting procedures and your contracts are consistent with whatever you'll certify to that regulator. And I mentioned the Unfair Deceptive Practices Act, both at the federal and at the state level. We are seeing more activity with regulators who will go after an entity for using data in a manner inconsistent with those policies or inconsistent with customer agreements. So please don't adopt those policies and forget about them. Make sure you are incorporating them in your contracting to the extent that that is appropriate. Additional contract diligence, technical capabilities, of course, are very important. I think both on your side and on your vendor side. Contract boilerplate can sometimes require or expect things that in practice are not going to be followed through on. And so I think it's important for you as the attorney, maybe you've got some technical background or have picked up that technical background. In most cases, it may make sense for you to involve somebody from IT with a technical background to make sure you understand a contract provision, whether it's in your contract or in the vendor's contract. What exactly is this saying, and what kind of capability do we need to make sure that the vendor has? And that kind of leads into that next point of vendor-specific risk assessment. I think especially if you are dealing with high risk and highly sensitive information that you're sharing with a vendor for any purpose, you'll want to sit down and think at least a little bit about what is the profile of this vendor. So are we afraid of an unintentional breach here, that the vendor is just a little bit small or a little bit sloppy in the way that it approaches data privacy, and we're going to end up with a laptop left on a park bench in some way, shape, or form? Do we think that there's a risk here of an intentional breach, where a disgruntled employee or somebody with connections to a competitor in the industry or to a data broker is going to share our information intentionally for profit or for nefarious reasons? Is the real risk a third-party attack? And I really can't suggest that anybody could guarantee that they're not going to be subject to a third-party attempt to access your data. And so for most vendors, I think the most likely issue is going to be a third-party intrusion or a third-party attack, which may come from a bad guy or a bad government, as we've seen in connection with the Sony pictures example. You're going to want to think about, or maybe ask even the vendor some questions, or incorporate into your RFP or other procurement documents, what are the strengths and weaknesses of their internal security policies? Are you going to ask to look at their policies? If you have looked at them, do they appear strong or do they appear relatively weak compared to what you understand to be required in your sector? Strength and weakness of technical and physical controls. And so again, where are you at in connection with what you see as important for a vendor to have in place in terms of where they may be storing physical copies of your documents or electronic copies of your documents or information. Knowledge, awareness, or compliance gaps. Again, if you're asking some questions about security and data security and the vendor doesn't seem to know what you're talking about, that's a good sign that the vendor may need to be educated on what exactly it is you need to have in place to comply with the law. And so it is, I think, easy at times to make sure that at least there is some knowledge and awareness, and that if there are any compliance gaps, you can address those either in the contract or by asking the vendor to address them before you do enter into the contract. On contract diligence, then, some high-level considerations here. I think you need to understand your data, and so is that data personally identifiable consumer information? That is the riskiest data that I think you have to deal with. If that information is personally identifiable consumer information, I think at that point you want to All right, sorry about that. So we're on contract diligence and just some high-level considerations. The riskiest data that I think we have to be concerned about from a data privacy standpoint is, of course, this personally identifiable consumer information. There is a lot of discussion in the privacy and in the data industries about de-identification and re-identification. The importance of that, of course, is the risk that a consumer is in if somebody gets access to their personally identifiable consumer information.
Go ahead and click on it.
Is that working, Kristen? Sorry, we're having some technical difficulties here.
No, it seems like when the little red thing closes, we lose it. So,
Keep that open?
Yep.
Okay.
Click on it one more time. No, leave everything up and then click on the slideshow. Yeah, now it's back.
Okay. Sorry about that. All right, we're back. I think another thing I want to point out, especially with some recent activity, is the vendor a data broker? And so a data broker is really a party that gets access to consumer data other than from the consumer. Did we lose it again? So be careful, in particular if you're dealing with data brokers, because I think the FTC is paying additional attention to business practices that involve the sharing of information with those data brokers. We may continue to drop slides. I'll try to get those up as I can. The other thing I think you need to consider from a high-level perspective is your enterprise approach to compliance and management. So is it going to be your policy as an enterprise that you want to identify and maintain and comply with reasonable data privacy and data management practices, or are you trying to identify and comply with your best practices? And so your enterprise approach to compliance is important, and I think your vendor's enterprise approach to compliance is important. It's something that you're going to want to consider as you enter into a contract. We are working with Christy to try to get the slides back up here. Looks like it's down again. Appreciate everyone's patience as we work through this here. taking it far away. Okay. All right. I think it might have been my wandering mouse cursor. High-level considerations, and I don't have to run through all of these, but again, the sensitivity of the data. You've got to think about where and from where the data will be stored or processed because of the jurisdictional issues that we discussed earlier. Can that data be disaggregated or transformed, or will it be used other than in its raw form? And will that have any impact on those regulations or laws you may be subject to? And then again, some of that vendor profile information that we discussed earlier. We'll move then from the overview into the contract and some of the priority terms as it relates to data privacy. Confidentiality is, of course, first and foremost. I think most of our vendor contracts are going to have confidentiality provisions in them. I think to the extent that you are dealing with a contract that might involve sensitive consumer data, you are going to want within your definition of confidential information perhaps to carve out a specific subset as either personal information or consumer information or some similar defined term that you will then have some special requirements or perhaps special indemnification or other commitments involved with. And so in some cases it may be that you decide that your typical confidentiality language is good enough to protect your consumer data. In other situations, it may be that you need to take a hard look at what your current confidentiality information requires or provides in terms of a commitment from your provider, and they need to carve out a subset, or maybe need to ask for more protection for all of your information that you're sharing. Limitations of liability are important, obviously an important contract term. I think in the data privacy world, it is possible now to target data-specific risks or to find contract language, whether it's in the business associate agreements that the HIPAA folks have out there, but lots of examples of targeting data-specific risks either to be not capped or to have no limitation on the liability that the third party may have to you for a breach involving data security. You can exempt a breach, for example, of consumer information from a cap or exclusion on liability. Indemnification. Is your indemnification going to be limited to third party claims? You know, that's sort of a common question in any contract. More important in the data privacy concept than maybe others is this idea of defense and control of a claim. And so if your vendor breaches the specific confidentiality provisions we have for consumer information in the contract, does then the vendor have control over any communication we've got to make to consumers about the breach? My suggestion to a client would be no. You want to make sure that your indemnification provision provides that you have control over any communication with your consumers. Then you've got to look at your statute. What kind of timeline are we under to give that notice to our consumers? We've got to make sure in the case of a confidential information or consumer information breach that we get notice of that from our vendor in time to notify our customers and comply with our requirements under the law. And so it takes a little bit of thinking and a little bit of, I guess, careful incorporation of your legal obligations into your contract with your vendor. Additional priority terms, warranties, of course, are important. What do you want your vendor to warrant or certify to you? I think those warranties or certifications can be operational. These are the physical and cyber safeguards that we have in place as a vendor. We're going to have those safeguards or better in place throughout the term of the contract. Technical bleeds into that, I guess, as well in terms of what is their security capability, and again, does that warrant technical review from you as a contracting party? How general or specific do you want your warranties to be? Are you going to have or ask a vendor to comply with all the laws that govern your data or the data that's being shared with the vendor? Something very general like that. Are you going to try to go in and get some specific commitments from your vendor that then tie back to what you're obligated to do under the statute? Or are you going to push for more? Even if you are not required to do X, Y, or Z under the statute, is it your enterprise practice, again, to go the extra mile in protecting consumer data, and you want to expect or are going to require the same thing from your vendor? Like any representations and warranties, I think those are most effective if they're tied to some remedies for breach. And so what is the remedy if your vendor is breaching a warranty? Is there a different remedy if it's a breach of a warranty involving consumer data versus some of the other reps and warranties that you're going to get from your vendor? Termination, this is something I think you need to think carefully about on the front end. And so as you're setting up the term of the contract, especially if it's a contract that is very data-centric, it may make sense for you to say the term of this contract is going to be whatever the term, 2 years, but continuing until all of the confidential information or consumer information that's shared is returned or destroyed under whatever procedures you've identified in the contract as being required of your vendor. And so it may be that your contract's not going to terminate until you're satisfied that all of the data is back in your hands where you think it's safe and secure. It may be that you're going to have a more standard termination, but there's going to be specific transition assistance and a specific term in the contract that says the data protection or data requirements in the contract will continue until that transition assistance is completed. So think about term and termination in the context of possession of data and when will you have that data back that you feel is secure without having a contract with that vendor. Other common terms, defining vendor data usage and access rights, assigning vendor responsibilities and risks relating to data, identifying those applicable security standards and procedures, and then an important one that you don't want to lose sight of is your vendor allowed to subcontract, even offshore, for larger enterprises? And if they are, do we understand what different rules or different procedures need to apply to anything that's going out to a subcontractor? If subcontractors are being used, are you going to ask the vendor to then get certifications from those subcontractors, audit rights from those subcontractors? How do you want to tie your vendor's responsibilities to those subcontractor responsibilities so at the end of the day you have an effective and enforceable remedy should something be done improperly or go wrong with your data? Again, your data is your enterprise's asset. It's a risky asset, and I think one that in a lot of circumstances is going to merit protection. And increasingly, I think we've got a responsibility to act reasonably to avoid, again, maybe some broader restrictions if there's a federal statute or if the FTC is going to continue to be active on consumer privacy issues. Some additional contract terms, assigning responsibility for data breach, including those costs of notices and remediation. So again, I think your indemnification provisions require some careful review to make sure we understand whether costs of remediation and costs of customer notices especially are covered by that indemnification. I mentioned earlier that I think you want to maintain responsibility for communicating with your consumers, but at the same point in time may want clarity that that is covered by indemnification or is not covered and is going to be paid for or not by you or by the vendor. Defining those requirements for the return or disposal of data and security transition assistance as your relationship winds down with that vendor. Again, I think that requires some careful thought on the front end. And then audit rights. It's important if you're going to have audit rights, which in many cases I think you are going to want to at least have the option to audit security and other protocols. What are the scope of those rights? Do they continue beyond the term of the agreement? And if they're not going to have audit rights or even with audit rights, will you require some certification from your vendor on an annual or other basis? And if so, do you want to attach a form of that certification? Do you want to dictate when that certification will be provided and what it will say, who will sign it and provide it to you, assign responsibility for that as well. Some common sticking points then as you negotiate terms with your vendors or third parties relating to data security. I do see pushback frequently from vendors on whether a law is or is not applicable to a specific use or to specific data. It's obviously important as attorneys that we understand the lay of the land and so that we can effectively advise our clients. Is the law applicable? Is there a gray area? If the law is applicable, does it carry a high level of risk to us if there's a breach? Do we have a specific responsibility as it relates to a vendor or to a third party? If we've not, or even if we have had a debate about which law is applicable, are we in the contract assigning somebody to monitor compliance and coordinate adjustments to the contract? So we sign a contract involving consumer information today with a term of 5 years. In a year and a half, Congress acts and adopts a federal law that then applies differently than the law at the time we contracted. Do we have language in our contract, a change in law provision, or similar language in our contract? Maybe we do. Who's monitoring that, and who is going to bring it to the attention of the parties and ensure that proper changes to our contract and to procedures in our contract are changed if we think that's, number one, necessary, and number two, permitted or required under the contract. And then, of course, who pays? If there are adjustments to procedures, if there are adjustments to requirements, do we want to try now to identify who would be responsible for the costs incurred with any changes? Liability, as in any vendor relationship, there is often discussion and negotiation of your liability provisions. Are consequential damages excluded generally? If so, are they excluded for consumer data privacy breach? I've talked at length about which party has responsibility and control following that breach. And then don't forget about insurance policies. I think you want to be familiar with the insurance policies for your client or your enterprise. You also might encourage the vendor or require the vendor to have specific cybersecurity or other insurance in place. And at that point in time, I think both parties can educate themselves on what their policies do and do not cover, and can get appropriate commitments, which sometimes can help break the sticking point on a liability issue if we're dealing especially with an insured risk or a narrower area of risk which is not going to be insured and which we're going to ask a vendor to maybe take more responsibility for. Contract performance, I think this is important and something that I myself have to continually remind myself of. I think it is easy to go through a negotiation with a vendor, especially if we're dealing with risky data and a risky contract, win some important concessions in the contracting process, negotiate exactly what it is we were shooting to negotiate, pat ourselves on the back and go on to the next deal, go on to the next piece of work. Who's going to monitor that contract? And so we shouldn't forget on our side, visiting with our client, that if we've got an audit right, if we've got some vendor performance requirements, if we've got changes in law or changes in public perception, what changes or what commitments do we need to make to follow up in performance of that contract? And so, you want to monitor your vendor for performance. I think you want to monitor the industry, whatever industry you're in. I think you want to monitor cybersecurity and data privacy, which are sort of becoming industries of their own, to make sure that you understand the changing landscape that may be out there. And of course, media coverage is something you want to monitor because once it's in the news, it begins to matter to customers, it begins to matter to shareholders, and it begins to matter then to the folks in the boardroom, the officers and directors who are accountable to the questions they may be getting from shareholders. But as we see an increased emphasis, I guess, on corporate responsibility, we're now starting to see cybersecurity and data security entering into that conversation as well. And so it's going to have increasing importance, and I think get increasing emphasis high up in your enterprise as we go along. Vendor certification, so that's another performance issue, and audits. Again, if you negotiate for those rights, I think in many cases you may have a policy that either encourages or requires you to exercise those rights on a regular basis. I think there are perhaps audits of your own organization or your own auditing process that you can incorporate and request that the vendor incorporate. And certainly it provides maybe some opportunity to coordinate on timing. If you've got a vendor and you're a key account for that vendor, perhaps it's even possible for you to say, hey, look, we audit our own security, data security performance once annually in September, and we want to include you in that audit. And again, if it's an important enough account, that may be acceptable to your vendor. But take advantage of efficiencies where you can find them. And again, it may help them with the tickler. Hey, when we do our own audit of our own practices, we're also going to audit third parties who provide services to us. So that's it for the, I guess, high-level discussion of what we need to think about in terms of contracts. We will get to some terms later. I am going to move now into customer proprietary network information, which is CPNI. And again, what I hope to do with this is just use it as a quick example of some of the concepts that we've been discussing here more generally. So customer proprietary network information is a type of consumer data that telephone or telecommunications carriers obtain about their customers in connection with telecommunications services. And so it became part of the legal landscape, I think, back in 1996 with the adoption of the Communications Act. And since that time, we've seen a shifting emphasis on this customer proprietary network information. So in the beginning, it was customer information. There was, I think, a consumer protection component to it, but so much emphasis in the 1996 Act was on competition that really what the Act said about CPNI was that we needed to share it with a competing carrier who the customer may be changing their phone service to, but that we could not share it with other third parties without some disclosure and or with the direction of the customer. And again, what happened over time is a provision in the law that at one point was viewed primarily as dealing with playing nice with competitors who asked for information about our customers in connection with a change of service. Around 2006 and into 2007, the FCC became very concerned about a practice called pretexting, where somebody would call the phone carrier and say, hey, this is your customer. I made a couple of phone calls last month, and I just want to make sure that those were billed properly. Can you remind me which numbers I called on this day at this time? Well, it turned out that that was not the customer. It might be a private investigator or somebody else pretending to be that customer and being provided with information over the telephone without verification to that being our customer. So the FCC became very concerned about some high-profile examples of pretexting and adopted an order in 2006 or 2007, as I say 2006, 2007 sounds right to me, which really then made the emphasis on eliminating pretexting as a business model. That at this point in time, telecommunications carriers, if you ever tried to call and ask your carrier for information, they've got to have a password or some other way to verify that it's you or another authorized account owner who's asking for this account information. Now we've shifted, I think, in the years since 2007, pretexting was addressed and we're into a more consumer data privacy driven emphasis, and so we're seeing some active enforcement from the FCC, and we're not seeing that enforcement again on sharing with a competitor or not sharing with a competitor. We're not seeing that enforcement so much on pretexting anymore. The rule seems to be effective to address that. Now we're seeing that in terms of our data privacy policies, the disclosures and notices we're required to send to customers, and lo and behold, Verizon was the most recent example of paying a $7.4 million forfeiture because it was using customer data to market services to customers outside of what the CPNI rules permitted or contemplated. And so I think this is probably a good example of what's happening in a lot of industries and a lot of sectors. You may have some statutes on the books, whether they're changed or not changed, you may see a regulator get more active in enforcing what currently exists. And so, again, just another reminder to know those rules and know your agency. So CPNI, the federal law governing CPNI, I talked about that statutory analysis previously. Who is covered by this law? You can see there it applies to telecommunications carriers. What kind of information? Customer proprietary network information, but not just customer proprietary network information, but customer proprietary network information that the carrier gets by virtue of providing that service. And so the emphasis, again, is on a telecommunications carrier and a customer of a telecommunications carrier and customer proprietary network information. So as we look at that statute, we want to be sure we understand who is covered and what types of information are covered. There was an ex parte filing with the FCC recently by a group that calls itself Consumer Watchdog, and they've asked that these same requirements, Section 222, be applied to broadband service providers. And so that may change over time, but right now the issue is a telecommunications carrier and a telecommunications customer. You could have different rules or different approaches to your broadband customers if you provide broadband service in addition to telecommunications service. And again, your contract with a vendor then on one part of that data may be different than your contract with a vendor on the telecommunications piece of that data. So the governing statute, again, is instructive as to who is covered and what types of information. The definition then of CPNI from the statute, and so again, the emphasis on telecommunications service, customer receiving telecommunications service, and an exception for subscriber list information. So then a quick definition of subscriber list information. But again, for you attorneys, it's becoming obvious that as we deal with the contract, if it's a contract just with subscriber list information, we have a different set of concerns and maybe a less intense set of concerns if we're just sharing subscriber list information versus if we're sharing customer information that we think is covered by the definition of CPNI, which is a fairly broad definition in terms of some of what we see for consumer data privacy. And so another note on that statutory or contract analysis, CPNI may or may not involve information that may be subject to a state breach disclosure law. And so you're going to want to understand both your sector's requirements, but also the state or states that you're operating in. Do they have requirements then that apply to all or some of that information? So we take a second look then at federal law, and we see, importantly, I think, what exactly is required and what exactly is the restriction. So we've got an exception there. So except as required by law, so subpoenas and some other avenues to share that information with law enforcement or with the approval of the customer. And so we can't become so hyper vigilant as telecommunications carriers. I'm frequently advising clients on questions that I get about a consumer who's asked that their information be shared in some way that makes the company uncomfortable. And at least from a CPNI perspective, I'm able to advise the client, well, your customer is requiring or requesting that you share this CPNI. I could make the case that you've got a legal requirement to do exactly what they're asking. And in some cases, you do have that legal requirement. And then again, the emphasis in the statute on individually identifiable information. So we may be able to de-identify that information in some way that it cannot be re-identified. And if we can do that, we may be able to share the information with fewer restrictions required in our contract if we're able to deal with aggregate information or information that can't be used to individually identify a telecommunications customer. There are some additional legal responsibilities. So again, you're going to break down your own sector statute, but we've got to notify customers of their right to approve any use or disclosure of CPNI. We've got to then use or disclose that CPNI only with the customer approval or in another authorized manner. We talked about those exceptions in the statute. We've got an affirmative obligation to take reasonable steps to safeguard our CPNI, and so I do contracts with third parties and having responsive terms in contracts with third parties as part of that safeguarding. We've got an affirmative obligation to notify law enforcement agencies if there is a breach of the customer's CPNI, and then we've got a self-monitor and a self-certify requirement under CPNI. And so, I've talked about those previously. We've got again, a clear obligation to notify law enforcement. We've got to notify law enforcement in many cases, following notice from a vendor. And so we'll talk a little bit about those timelines. And then we've got to, monitor and certify. And so we may need some audit rights, or at least need to have something established for how we're going to monitor our vendors' compliance with whatever we have in the agreement dealing with CPNI. We are going to be called on. An officer of the carrier is going to be called on every year to sign that CPNI certification. And so very important that that person be familiar with whatever it is we've got as a policy or as contract terms for contracts dealing with CPNI. So we've got some safeguards. The carrier's got to establish adequate operating procedures, have a system for determining what consent we do or do not have from customers, be able to verify customers with account security and customer authentication, you got to train your personnel about when they are or not authorized to use or disclose CPNI, and you've got to identify that compliance officer having personal knowledge of the adequacy of our procedures. So how much of this then again finds its way down into your contract with your vendor? Do you want to have a specific or affirmative obligation that your vendor is going to have to train its personnel about CPNI and what obligations we're under and the vendor may be under the contract in connection with CPNI? Are you going to require your vendor to identify an officer who will then certify to you that there has not been a CPNI security breach during the year with any CPNI in the vendor's control? Some additional safeguards, the marketing safeguards, supervisory review and approval of marketing campaigns that involve CPNI, and then maintaining that record. So again, these are very relevant to a contract with a vendor who may have access to our CPNI to provide a billing service or another service for us or for some other reason. And we're going to then perhaps ask that company also to provide some marketing of other or different or the same services. There are different requirements, but certainly some reporting requirements and some monitoring or record-keeping requirements that we may want to incorporate into our contract, saying that the vendor will give us the information we need in order to make that report to the FCC. I talked about the notification, so we've got to notify law enforcement of a breach as soon as practical. In most cases, unless the law enforcement agency says otherwise, not less than 7 business days, and then notify the customer 7 business days after notice to the law enforcement agency. We may have to notify sooner if the customer's safety is at risk, or we may have to notify later if the law enforcement agency says, hey, we're investigating this. We think notifying the customer may be materially adverse to that investigation. We're going to ask you to hold off on notification. We've got to make sure that we calibrate the notice provisions from our vendors so that we can timely give notice to our customer and timely give notice to our law enforcement agencies. And so a little, I guess, potential trap for the unwary, if your contracts don't require notice from your vendor at any time or maybe 10 days, and you've already breached your obligation to get notice to law enforcement within that 7 days, then we've got to maintain records of those breaches. The CPNI certification, we've got to certify then our compliance with CPNI. I mentioned it is a self-monitor and self-certify. Telecommunications carriers file that annually by March 1. An officer's got to sign that, and it's got to include a statement explaining how our procedures comply with what's required. So again, in terms of a vendor relationship, do we want a certification from that vendor? Do we have to have that certification in the first part of the year so that we can roll it into our certification that we make to the FCC on March 1? Are we going to require our vendor to have an officer sign, or can it be anybody? Maybe the account manager or somebody less than an officer. Does the officer designation maybe carry some more heavy emphasis with it so that we're more assured that the vendor is in compliance? And then what does our statement that we file with the FCC say about third-party vendors, if anything? We don't want to make an inaccurate statement in our certification. For example, we have provisions in all of our agreements that require our vendors who deal with CPNI to indemnify us. to the fullest extent permitted by law. We don't want to make that statement if that's not accurate. So be sure on an annual basis you review those certifications and they accurately reflect what, if anything, you're saying about those third-party contracts. More information on that certification, and we've discussed that. So, sample terms then, and we're running short on time. If you've got a CPNI contract, we've got a statement there. This is a statement that the vendor shall fully comply with. This is sort of that broad statement that I mentioned earlier. Vendors shall fully comply with all applicable rules and regulations governing access to customer proprietary network information, and then we're just going to cite to the statute. So this sometimes works and maybe works very well if you've got a vendor who works with telecommunications carriers almost exclusively or primarily. In other cases, you may want a more specific statement. So we'll go into the statute, we'll look at what it requires, and we'll put down on paper, you're going to comply with those rules, including you're going to use or disclose CPNI only to perform services, only for your proper management and administration of those business functions or legal responsibilities involving the services, or as required by law. So that is a little bit more specific, ties back to the statutory language, and perhaps assures or saves the vendor the problem of having to go back and understand what it is that the law requires. This is just one piece, because as I mentioned earlier, you're going to want to think about and try to address changes that may occur to the statute, and in particular changes that may occur to the rule, and whether that then the vendor's obligations are modified by those changes, or are they being locked in at the time that we contract. Some other sample terms, a breach provision, and so again, maybe a broad requirement that you are going to indemnify us and hold us harmless, cooperate with us in mitigation or remediation, but A is, of course, that immediate notice. And so people are going to, again, negotiate these terms. Is it immediate? Is it prompt? Is there a specific day, a business day requirement? Tie that to what you need as an enterprise to comply with what's required of you. And then I've got a more specific breach notification and breach indemnification provision here. Again, just a small sample of what you can use or terms that you can use. And then finally, we've got an indemnification clause. And again, this one is fairly general, and you can play with it just like you can in other contexts in terms of dealing specifically with what it is you've identified as the risk that you're most concerned about, or that you think the vendor should bear the greatest responsibility for. So just some sample terms there. I think, or I hope it's been useful to talk a little bit specifically about CPNI, simply as an example of how those terms can be used. I want to make sure we leave time, and we got maybe just a little bit of time left. If anybody's got a question, please go ahead and shoot your hand up. Otherwise, I've got a couple of quick takeaways for you. One is to use good procurement practices. I think that's true in any vendor relationship. Do that due diligence. Coordinate your technical, business, and legal review. Hopefully you've got people, if you're a large enough organization, that you can work with in those areas. Understand your data and the risks to your enterprise. Prioritize those risky contracts and risky relationships. I think, again, emphasizing that all consumer data at this point appears to be risky. Focus on those high priority terms, including many that we touched on today, and then monitor that performance as the contracts go through. So if I don't see any questions here, I don't see any hands up. There's my contact information. Feel free to shoot me an email or give me a call. Christy, I'll turn it over to you.